You get home, and taped to your door is a notice that says you have 3 days to leave. Your stomach drops. Is this real? Do you actually have to leave in 3 days? Almost everyone panics in this exact moment, and panic is exactly what gets people into trouble. By the end of this video, you'll know exactly what steps to take, in order, plus the exceptions and edge cases most guides skip entirely. First thing to understand, that notice is not an eviction. It's the start of a legal process, and that process has rules the landlord has to follow. There are 3 common types of notices, and which one you got changes everything. Pay or quit usually means you're behind on rent, and paying in full within the notice period can stop the whole thing. Cure or quit means you violated some other part of the lease, like having an unauthorized pet, and fixing the issue can also stop it. Unconditional quit, the serious one. No fixing it, no paying your way out. This one usually follows repeated violations. Step 1. Read the notice carefully and confirm it's actually valid. Landlords mess up notices constantly. Wrong dates, missing required language, or not giving the legally required number of days. A single mistake on the notice can make the entire thing invalid, meaning the clock hasn't even legally started yet. Now here's something most people don't realize. The number of days you actually get depends entirely on your state. In California, most non-payment notices require at least 3 days. In New York, it's usually 14 days for non-payment. Texas generally requires at least 3 days too, but Florida gives tenants a bit more room depending on the violation type. These numbers change constantly as local laws update, so treat this as a general guide, not a substitute for checking your specific state or city. Some cities layer on extra protections on top of state law. Several major cities require just cause before any eviction, even at the end of a lease. So step 1.5. Once you know your state, look up your state's specific notice period before you do anything else. Step 2, never ignore it and never just move out because you're scared. Here's something most people don't know. Your landlord cannot legally force you out themselves. No changing the locks. No shutting off your utilities. No physically removing your things. This is called a self-help eviction, and in almost every state it's illegal, no matter what the notice says. The only way a landlord can legally remove you is through the court system. Now let's talk about protections most tenants don't know they have. Under federal fair housing law, a landlord cannot evict you or treat you differently because of race, religion, sex, disability, or family status, including having children. If you have a disability, you may also be entitled to a reasonable accommodation, like a slightly longer timeline to address a lease violation. If you recently reported a health or safety issue, like mold or a broken heater, and suddenly got an eviction notice right after, that timing matters. Many states have retaliation protections that make it illegal for a landlord to evict you specifically because you reported them or asserted your rights. If your notice showed up suspiciously close to a complaint you filed, mention that timeline explicitly when you respond. It can be a defense on its own. None of these protections make the notice disappear automatically. You still have to raise them, usually in writing or in court. But knowing they exist is often the difference between people who fight and win and people who assume they have no options. Step 3. Respond. If it's a pay or quit notice and you have the money, paying in full within the window usually stops everything. If you can't pay or you disagree with the notice, you wait, because a notice alone doesn't remove you. Only the landlord actually filing in court moves things forward. If they file, you'll be formally served court papers, and you'll have a strict deadline to file your response, called an answer. Missing that deadline is one of the single biggest mistakes tenants make. It can result in an automatic loss, even if you had a good case. Now, your specific situation might not fit the standard tenant-landlord setup, so let's cover a few common variations. If you're on a month-to-month lease instead of a fixed-term lease, your landlord generally still needs to give proper notice. They can't just end things overnight. If you're subletting from someone who isn't the actual property owner, your legal standing can get more complicated, and you may need to loop in the original tenant or check your sublet agreement directly. If your lease already ended and you're staying month to month by default, most states still require a notice period before the landlord can ask you to leave. It's not automatic. If you never signed a formal lease at all, you likely still have tenant rights once you've been paying rent and living there. Verbal agreements generally still count. The core process stays the same in all these situations. Read the notice, confirm it's valid for your arrangement, and don't assume you have zero rights just because your setup isn't standard. Step 4. Start gathering your evidence early and gather more than you think you need. Start with your payment history, bank statements, receipts, or money order stubs proving what you've actually paid and when. Save every text, email, or written message with your landlord, especially anything about repairs, complaints, or disputes. Take photos or videos of anything relevant to your case, property conditions, damage, or repairs you requested that were ignored. If you have a neighbor or roommate who witnessed something relevant, ask if they're willing to write a short statement or testify. If you reported a health or safety violation to a local housing authority, get a copy of that complaint and its timestamp. Organize everything in the order it happened. Judges respond well to a clear timeline, not a pile of loose paper. If money is tight, look into free legal aid. Many cities have tenant rights organizations that will represent you at no cost. Some areas even guarantee a lawyer for eviction cases specifically, so it's worth checking before assuming you have to handle this completely alone. Step 5. Show up to your hearing. Not showing up is the second biggest mistake. It usually means an automatic default judgment against you. Arrive early, dress like you're taking it seriously, and bring physical copies of every piece of evidence you gathered. At the hearing, you'll explain your side, present your evidence, and the judge decides. Judges generally care about 3 things. Was the notice valid? Is the reason for eviction legitimate? And do you have a documented defense? Stick to facts and dates. Emotional arguments matter less here than a clear, organized timeline. If you win, you stay, and in most cases the landlord can't simply try the exact same claim again immediately. If you lose, the judge sets a specific move-out date, and even then only a sheriff or court officer can physically remove you, never the landlord. In many states, you also have a short window to appeal the decision if you believe the judge made a legal error. Let's cover a few quick questions people always ask after watching videos like this. What if I already moved some belongings out before the hearing? You can still fight the case. Moving some items doesn't waive your right to respond. What if the eviction notice doesn't state a reason at all? Depending on your state, landlords may be required to state a legitimate reason, especially in rent-controlled areas. What if I paid late but the landlord already accepted a partial payment? In many states, accepting partial payment can actually restart or void the current notice, worth raising in your response. What if I can't afford to move out even if I lose? Ask the court about a stay of execution, a short additional window some judges will grant in hardship cases. So here's the real takeaway. A notice taped to your door is scary, but it is not the end of the story. It's step 1 of a process with rules, deadlines, and real protections for you. Read it carefully. Check your state-specific rules. Don't panic. Don't ignore it. Don't move out early. Gather your evidence, and always show up. This video is general education, not legal advice. Laws vary significantly by state and city and change over time, so check your local tenant rights resources or a licensed attorney for your specific situation. If this helped, the next video breaks down exactly how to win in small claims court. Subscribe so you don't miss it.